Welcome back. You're watching Newsx and I'm Vaishali Kohli. Now, the Supreme Court of India has rejected the bail pleas of Umar Khalid and Sharjeel Imam lodged in Tihar Jail under the Unlawful Activities Prevention Act linked to 2020 Delhi riots. The bench added that Khalid and Imam can plea for bail after 1 year and after the completion of examination of protected witnesses. Meanwhile, the top court granted bail to 5 other accused in the case, adding 12 strict conditions. For more than 5 years, the 2020 Delhi riots case has been at the center of intense legal, political and civil liberties debates. Today, the Supreme Court of India delivered a key judgment, and the outcome has significant implications for the justice system. Bail, jurisprudence and how anti-terror laws are applied. But who is Umar Khalid and what was he charged with? Well, Umar Khalid is a former research scholar at Jawaharlal Nehru University who rose to prominence during protests against the Citizenship Amendment Act. In 2019, however, what Umar and his friends called activism sounded more divisive. In fact, in an infamous remark, Sharjeel Imam was trying to provoke a large crowd to block road and rail connectivity to Assam and cut India's chicken neck off. In February 2020, violent riots broke out in parts of northeast Delhi. The clashes left 53 people dead and hundreds injured, a chapter that would later become the subject of a sprawling police investigation. Delhi police arrested Khalid in September 2020, accusing him and several others of being part of a larger conspiracy behind the riots. He was charged under the Unlawful Activities Prevention Act, India's anti-terror law, along with sections of the IPC, with the police alleging that the violence was not spontaneous, but a deep-rooted, pre-planned and premeditated attack tied to the broader anti-CEA protests. Over the years, Khalid's bail pleas were repeatedly rejected, initially by the trial court and then by the High Court. Surprisingly, several leaders in the USA have warmed up to Khalid despite the gravity of the cases against him. In fact, in December 2025, New York City Mayor Zohran Mamdani wrote a personal handwritten note to Umar Khalid. The note delivered to Khalid's parents during their visit to the US reads, "Dear Umar, I think of your words on bitterness often and the importance of not letting it consume oneself. It was a pleasure to meet your parents. We're all thinking of you." All right, now joining us is Senior Advocate of the Supreme Court and former ASG of India, Aman Lekhi. Mr. Lekhi, welcome. And I'd like to begin by asking you, what is your first reaction to the Supreme Court order?
Well, I'm disappointed. I personally feel that it neutralizes what is the statutory function and the constitutional underpinning of the grant of bail, and it impacts adversely institutional credibility. But what is most important is that it creates a halo around those against whom this order is passed and makes them a symbol of a dysfunctional legal system. I am particularly concerned by a few expressions the court has used because that they show, in my opinion, undue deference to the executive and trivialization of delay. Now, as a delay is concerned, I have read in the news, the word used is trump. It's not Trump, but the point is that delay may not be a trump with the accused, but is nevertheless, while not being decisive of the entitlement, yet determinative of it, and is indicative of, in some way, structural failure, for which the onus is on the state. Now, this reverses the onus and, in fact, treats it in a rather shallow manner insofar as a claim of right which the accused has to make, with which I don't agree. Whatever I've read, as I said, as far as the order is concerned, what it actually suggests is a bit of caution in dealing with this. But while being cautious in dealing with it, it's more or less abdication insofar as the responsibility is concerned. I may not agree with Umar Khalid's politics. In fact, I find whatever he said about Afzal Guru indefensible. But what is important is not what Umar Khalid did. What is more important is the process by which Umar Khalid has to be dealt with. And as far as the process is concerned, I personally feel that this particular order robs it of the meaning which is actually intended for it. A 5-year or 6-year custody, I mean, notwithstanding the mandate of the statute, in my opinion, is unacceptable, because what is necessary when the charges are grave is expeditious trial so that you pin guilt. And you cannot make the process itself punishment, and nor can you make detention an end in itself.
All right. Can you now help us understand your opinion on the UAPA case against Umar Khalid and Sharjit Imam now that the Supreme Court judgment is out?
Right. I just told, as far as this aspect is concerned, whatever I said was with regard to Umar Khalid judgment. What I'm saying is that this judgment, in my opinion, is legally incorrect. I've already said that and elaborated why I'm saying that. So as far as this issue is concerned, but what I'll flag in addition, because you're putting a pointed question, is what the Supreme Court is saying, that they can renew it in a year's time, provided the star witnesses or the more important witnesses are examined. And even if they are not examined, they'll be entitled to apply for bail. Now, this creates an artificial distinction, again, which law cannot possibly recognize, because either the more important witnesses have to be examined before they grant bail, or they don't have to be examined before they grant bail. So if the witnesses are not examined in 1 year's time and they're yet entitled to bail, I really don't see on what basis the Supreme Court can say today that because the witnesses are not examined, therefore they're not entitled to bail. So this is a facile distinction for which there is no legal basis, and doctrinally it's basically completely unsound. And I am at a loss to find a legal justification for this particular approach.
Okay. Now, what's now needed to quickly conclude this trial, and how important is it that this case finds its conclusion?
Every case has to find its conclusion. In this case, more importantly, because the allegations are grave, and because allegations are grave, we have not to speculate guilt, we have to prove it. And particularly when we have allegations as serious as those which have been made against Umar Khalid, which, if true, will reveal him as a truly notorious character, it is very important that punishment is actually imposed, rather than all of us debating whether he should have been released on bail, and he tweeting that, okay, this is going to be his life in jail, and so become a symbol of what is misdescribed as oppressive system. So this will not work to the benefit of India, it will work actually to the advantage of the accused, against whom rather serious allegations have been made.
Okay, but what about the Supreme Court observing the fact that delay is being used to engineer a bail in this case?
Delay is being used to engineer a bail, as far as the Supreme Court is concerned, would have reasons for it to actually conclude that that is so. In that event, if it is engineered for the purposes of granting of bail, the method adopted may be subject to some kind of adverse criticism where the person is concerned, but the delay by itself is not the factor which is decisive where the bail is concerned. Of course, very important matter, because my objection is the way in which the Supreme Court phrases this particular thing, because Supreme Court cannot be loose in terms which have determinative in other matters of similar nature. But as far as what you have to understand is that bail, notwithstanding the mandate of the section which talks about satisfaction about the person not being guilty, considering the period which has elapsed, has to be construed in a manner which is proportionate, because that will be the understanding behind that particular provision to keep it constitutionally valid. Now, if that is so, what the Supreme Court has to see is the totality of that particular matter and not lose sight of the purpose behind this particular provision. And the purpose behind bail is basically to allow release if there are causes to assume that there is unlikelihood of abuse of that particular liberty. So the decisive aspect, apart from gravity, is the conduct, and the two have to be balanced and have to be seen in the context of the circumstances of the case as a whole. This is a holistic consideration of the entire matter to be seen expansively and in an integrated manner, not in isolated silos or aspects which are in any way de-linked from each other, to have a complete picture. And if you have a complete picture and see the object in which the bail has to be granted, in that event, in the peculiar circumstances, one has to lean in favor of the grant and not rejection. More so when in a case of conspiracy, the other conspirators have been granted bail. I really don't know, I'll have to read the order as to how this particular distinction is sustained. But there's an inherent flaw in the judgment insofar as this distinction is made, because in conspiracy the role is more or less identical because the mandate of law, and the Supreme Court itself is saying that they can renew it after 1 year's time, when even if the main witnesses are not examined. So this is a contradiction within the judgment, which is to a mind trained incapable of proper reconciliation.
Thank you, Mr. Lekhi, for joining me on the broadcast.